and another, 1975, and Dr. Parma versus Sin Paul and another, 1959.
You have to prove
that it would be sufficient to nullify the election. My further findings are as follows. Firstly, the compact disc marked DOA1 containing 4 short MP4 video clips was played in court. The respondents did not adequately challenge its admissibility or the certificate of electronic recording then. They have chosen to attack it belatedly in their final submissions. The video clearly shows Mugaru at the county tallying center wearing a red and white shirt emblazoned at the back. Mugaru supports Governor Nyaribo. Secondly, he signed the 2 contentious Forms 37C at the tallying center as an agent of UPA party. I was unconvinced by the submission by the first and second respondents that, and I quote, he was not the same and only person, unquote, seen at the tallying center. I then redefined was an agent of the UPA party and showed his preferences openly at the county tallying center. I'll now turn to the allegation that Mugaru, or the first respondent, contravened sections 14 or 15 of the Elections Act. I will commence with section 15, which provides as follows, and I've set it out in great detail. I will not require to read it. So go to paragraph 165 of my judgment. Did the petitioner adduce sufficient evidence to prove criminal conduct or a corrupt practice to the required standard? The answer is in the negative for 5 main reasons. Firstly, and as I stated earlier, parties are bound by their pleadings. The petitioner pleaded that Mugaru was an employee of the County Public Service Board. A belated attempt to further amend the amended petition was declined for reasons on the court record. According to the publication of the County Assembly, marked as PMFI1, Mugaru was a member of County Assembly Service Board for Nyamira, a different entity altogether. Since this document was introduced by the petitioner after the close of his case and during cross-examination, it could only be marked for identification. The question arising then is whether answers given in cross-examination by the respondent's witness DW1 about that document established the petitioner's claim. Learned counsel for the petitioner cited Doabia and Doabia, the law of elections and election petitions, LexisNexis, for the proposition that I should not stress the doctrine of strict proof too far, and if I quote him, to the extent of making it nigh impossible to prove an allegation of corrupt practice, unquote. He also made extensive reference to the Nigerian case of EcoBank Limited versus Agaz, and I've set out the relevant paragraph of that decision. But I'm well guided on that point and bowed by the Court of Appeal in Kenneth Nyaga Mwige versus Austin Keguta and 2 others. Civil Appeal 140 of 2008, where the learned judges of the Court of Appeal stated as follows. Paragraph 20. Once a document has been marked for identification, it must be proved. A witness must produce the document and tender it in evidence as an exhibit and lay foundation for its authenticity and relevance to the facts of the case. Once this foundation is laid, the witness must move the court to have the document produced as an exhibit and be part of the court record. If the document is not marked as an exhibit, it is not part of the record. If admitted into evidence and not formally produced and proved, the document would only be hearsay, untested, and an unauthenticated account, unquote. Furthermore, the petitioner cannot meander outside his pleadings in which he stated that Mogaru was an employee of the County Public Service Board. I find that it was thus not established that Mogaru was an employee of the County Public Service Board as pleaded. Secondly, the petitioner did not establish that Mogaru was appointed as an agent of the first and second respondents. From the declaratory forms, it is apparent he was an agent for the UPA party. The Learned Counsel for the petition, Mr. Mwanza, was of the view that it makes no difference. I do not entirely agree. The difference between a political party agent and a candidate's agent and the implications thereof was well explained in Alfred Nganga Mutual and two others versus Wafinya Adeti by the Supreme Court in 2018. Thirdly, Regulation 62, Subregulation 6, explicitly denies admission into a polling center to someone displaying party symbols, badges, paraphernalia, or dress code signifying support to a party or candidate. I have not come across an express rule barring an agent from doing so after the close of polls at the county tallying center. The logic is obvious. At that stage, the voting and counting is long gone, and there are no longer voters capable of being influenced. Fourthly, DW1 and the IEBC had no control over the nomination of agents by candidates or parties. Their role was to ensure that the agents had an appointment letter, identification document, and had executed the oath of secrecy. The petitioner did not lead any evidence to show that the third and fourth respondents were complicit in any scheme by Mogaru or the first and second respondents to further a corrupt practice. Fifthly, and more importantly, the petitioner pleaded that the appointment of Mogaru amounted to criminal conduct. The petitioner's case is that Mogaru's activities amounted, I'll read that again. The petitioner's case is that Mogaru's activities, and by extension that of the first and second respondents, amounted to a corrupt practice in violation of Section 15 of the Act. Learned Counsel for the petitioner submitted that appointing Mogaru was a corrupt practice that, and I quote, vitiated the first and second respondents' ability to file for elections under Section 15, subsection 3 of the Elections Offences Act, unquote. As I stated earlier, in allegations of criminal conduct, such as those prohibited by Sections 14 and 15 of the above Act, the standard of proof is beyond any reasonable doubt. I do not in any manner condone the behavior or antics displayed by Mogaru. I find it to be despicable. The petitioner had also pleaded at paragraph 162 of the amended petition that the first respondent contravened Section 14 of the Election Offences Act. That section deals with use of public resources. Besides references to the employment of Mogaru, no other material evidence was laid on that allegation. From the evidence I have highlighted above and the legal analysis, I read find that the petitioner failed to prove beyond reasonable doubt that the first and second respondents used public resources or engaged in a corrupt practice in contravention of sections 14 and 15 of the Election Offences Act. This finding equally applies to the allegation by PW10 that a polling clerk at Manga TBC polling station was, and I quote, telling people to vote for Nyaribo, unquote. It was a bare statement and adorned by concrete evidence. One of the key prank Valentino's entries, I will comment on two preliminary matters. The first one is about the existence of two booklets of pre-printed Forms 37A. This matter arose largely in the cross-examination of the witnesses presented by the IEBC. The witnesses clarified that the two booklets had different serial numbers and that the presiding officers had firm instructions to only use the booklet and seal the other one inside the ballot box. I'll read that again. That the presiding officer had firm instructions to only use the first booklet and seal the other one in the ballot box. However, the issue of the two booklets was not pleaded in the amended petition at all. There was also a paucity of evidence on whether it impacted on the election. Noting the petitioner is bound by his pleadings, I then need not make a finding on it. The second preliminary matter revolved around competing claims about the authenticity of the Forms 37A annexed by the petitioner against those submitted by the IEBC. Learned counsel for the petitioner submitted that, and I quote, the Forms 37As as provided by IEBC are different from the ones in the possession of the petitioner and which materially affected the overall outcome of the results. The respondents, on the other hand, condemned the forms exhibited by the petitioner as outright forgeries. Where does the truth lie? At the pre-trial conference, I ordered the IEBC to furnish the court with certified copies of all the forms used to declare the results. They were lodged in court by the IEBC on the 7th of November 2022 and used at the trial. As I will detail later, some were markedly different from those by the petitioner. In the absence of clear evidence that the certified copies were fraudulent, the court would be minded to rely on them as the official results of the election. Equally, the IEBC was required to prove that the petitioner's forms were a fraud. The standard of proof for fraud is higher than a balance of probability. It approaches but is below proof beyond reasonable doubt. And I've referred to the cases of Ratilal Patel versus Laji Makaji and Umila Shah versus Barclays Bank International Limited.